Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown Employment Podcast. My name is Chris Fisher and I'm the head of the London Employment Group at Mayor Brown. We've got 3 cases to update you on in this episode of the podcast, and I'm delighted to be joined again by my partner in the group, Miriam Bruce. Miriam, hello.
Hi, Chris. It's good to be back.
It's good to have you back. We're looking, as I said, at 3 very different cases. First, a case about whether a 12-month non-compete covenant could be enforced against a solicitor. Secondly, the question of whether a resignation can amount to a dismissal by the employer if the employer exercises a payment in lieu clause. And finally, a case on whether an agency worker has the right to apply for vacant roles in the client organisation. I'm going to deal with numbers 1 and 3, and Miriam will deal with the middle case. So, first up is a case called Law by Design against Ali. And this was a High Court decision about a solicitor, Ms. Ali, who worked for Law by Design Limited, which was a boutique law firm covering the northwest of England. And Miss Ali was a senior solicitor. She'd qualified in 2006, and she specialised in employment law, specifically for NHS clients. And she joined Law by Design in 2013 and resigned in May 2021. She was subject to 2 non-compete clauses. The first was in her employment contract, which applied for 12 months after termination, and that prevented her from competing with the areas of business of Law by Design that she'd been involved with to a material extent in the 12 months before her termination date. The other covenant was in a shareholder agreement because during her employment, Miss Ali had been given some shares in Law by Design, albeit a very small shareholding of 3%. And the non-compete covenant in the shareholder agreement was also for 12 months, but it was wider because it prevented her from doing any business which competed with the Law by Design business during the 12 months before she ceased to be a shareholder. So it applied to all areas of Law by Design's business, not just the ones Miss Ali had been involved with. Now, as you can anticipate, Miss Ali left to join a competitor, and there was a dispute about the enforceability of the non-compete covenants. Ms. Ali argued that the clauses in both the employment contract and the shareholder agreement went beyond what was reasonable to protect Law by Design's legitimate business interests, and so should be struck down by the court. Specifically, she said that the company had other protections because it had a confidential information clause in the employment contract and a non-solicitation of clients covenant. Now, the court looked first at the employment contract, and they said that this clause was not too wide because it was restricted to the areas of business that Ms. Ali had worked in at Law by Design, which was employment work for NHS clients. And it also only applied to the geographic area of that business, which was the northwest of England. Now, they acknowledged that the confidentiality and non-solicitation clauses in the contract were there and gave some protection, but they said they were not necessarily enough. The common problem with these sorts of clauses, as we all know, is that they're difficult to police because it's not always clear what is and what isn't confidential information and what is information that an employee is allowed to carry away in their head and use in a new business. And of course, in terms of non-solicitation clauses, it can be difficult to know whether a client has been solicited by a former employee or whether the client has approached that employee or their new firm. So the covenant in the employment contract was upheld, but when it came to the shareholder agreement, the judge came to a different view. He said that the clause did indeed go further than was necessary to protect Law by Design's legitimate interests, because it was not restricted to the area of work that Ms. Ali had practiced. Although Law by Design was a boutique law firm, it did do commercial work as well as employment work, and it acted for clients outside of the NHS sector. And yet the shareholder non-compete was drafted so widely that it would stop Ms. Ali from doing work that she'd not done or been exposed to at Law by Design. The firm tried to argue that a more lenient test should be applied to non-compete clauses in commercial agreements, such as a shareholder agreement, as opposed to employment contracts. And it's certainly true that there are cases where the court will do that. For example, in business sale agreements, where we see much broader covenants being upheld when they're given by the seller of a business in order to give the buyer as much protection as possible for the goodwill in that business. But the judge in this case said that that was not the situation here. Ms. Ali was only a very small shareholder in the company. She owned 3%. And so the judge essentially applied the same test as he had applied to the employment contract. So that's Law by Design and Ali. And I think it's an interesting case for two reasons. First, there aren't many cases where you see a 12-month non-compete clause being enforced. And also because it's an example of something we do see very often with senior employees who have covenants in their employment contract, as well as often slightly different and slightly wider covenants in some form of share incentive plan. And the message from this case is that where that equity interest is only a very small one, then the courts are unlikely to apply a much more lenient approach to the enforcement of the covenant. And so employers are going to have to give as much thought to the drafting there as they would to the clause in the employment contract. Because as this case highlights, drafting really is key as to whether a covenant will be enforced. So that's Law by Design and Ali, and I'll move on now to our next case, which is all about resignation and payment in lieu of notice. And I'll hand over to Miriam to talk about this one. Miriam, this is a case we've chatted about recently, and it is very interesting. So over to you.
Thanks, Chris. You're right. This is an interesting one. It's the EAT decision in Fenton and Outform EMEA Limited. Now, the central question in this case was whether a resignation is converted into a dismissal by the employer, where the employer brings forward the termination date by making a payment in lieu of notice. For now, the good news for employers is that the answer to that question is no. If an employee resigns and a pylon is invoked, their resignation isn't converted into a dismissal. However, this case does appear to cast some doubt on that principle. So let's see what happened and what the future might hold for pylons which are deployed following a resignation. So in this case, Mr. Fenton worked for Outform and resigned in April 2019, giving notice pursuant to his contract, which would have expired in January 2020. However, towards the end of 2019, Outform realised that if they kept Mr. Fenton on the books until his January termination date, he'd qualify for a bonus payment. Instead of allowing that to happen, the employer decided to invoke the payment in lieu of notice clause in his contract and bring forward the termination date to December 2019. So Mr. Fenton's employment ended before the year end, and he was paid in lieu of his basic salary for the remainder of the notice period, as per the pylon clause, which also made clear that any bonus entitlement would be lost. Now, Mr. Fenton subsequently brought an unfair dismissal claim. That type of claim was his only option, as a constructive dismissal claim wasn't open to him, given his resignation back in April wasn't as a result of the employer's alleged repudiatory breach of contract. However, in order to succeed with an unfair dismissal claim here, he needed to convince the court that invoking the pylon clause in his contract converted the resignation into a dismissal by the employer. Now, the problem with that argument for Mr. Fenton was that there's a prior EAT case which went against him and said that invoking a pylon doesn't convert a resignation into a dismissal. And that's the case of Marshall and Hamblin. The existence of this prior authority meant Mr. Fenton's case failed at the tribunal. When he went to the EAT, he tried to convince the court to disregard the Hamblin handling case in its entirety on the basis that it was wrongly decided. His main arguments here were that the handling case had been criticised in commentary and that it went against a liberal interpretation to be given generally to employment protection legislation. In the end, in my view, the EAT came to the right decision. They rejected the claimant's appeal. However, it does appear to have been quite a closely run decision. Certainly, the EAT felt that the handling case was problematic in parts, but couldn't go so far as to say it was manifestly wrong. As such, Mr. Fenton lost his appeal, and employers across the UK can breathe easily for now, safe in the knowledge that exercising a pylon after a resignation will not automatically turn that resignation into a dismissal. As I say, in my view, this was absolutely the right decision. Whilst the EAT judge in this case appeared to have some serious misgivings about the principle, I think a finding in the claimant's favour here would have seriously undermined the usefulness of pylon clauses. If exercising a pylon is going to equate to dismissing an employee who's already resigned and creating a claim that didn't exist beforehand, you can see employers losing faith in the pylon route altogether. So this is certainly, though, a case to watch, as there's a suggestion it could end up in the Court of Appeal. And the EAT comments appear to have laid the groundwork for such a challenge. So I would definitely remember the case of Fenton and Outform to see what happens next.
Yeah, thanks, Miriam. That's it is an interesting case, and I mean, I know you say we don't yet know, I don't think, whether they're going to get permission to go to the Court of Appeal. But do you think, in the meantime, our clients should be changing their pylon clauses just in case the Court of Appeal does hear the case and they do change the position?
I don't think it's necessary to change a pylon clause. I don't think whatever drafting you came up with could circumvent a finding that a pylon converts resignation into a dismissal, if that's what the outcome is, if this case goes to the Court of Appeal. But there is a learning point for this case on drafting, I think, because what would have helped the employer in this case is if the contract had made clear that any bonus was lost at the point notice was given or received. In this case, the employer didn't have a clause like that. Instead, the clauses in Outform's contract said that the employee would get a bonus if they were under notice and had served out their full notice period and were employed throughout the relevant financial year. Now, the problem here was Mr. Fenton would have met all of those conditions if the pylon clause hadn't been exercised at the last moment in December 2019. So I think if there is a drafting change required, clients should be looking at their bonus clauses to make sure that it says that entitlement is lost if the employee is under notice. In that way, exercising the pylon doesn't become as financially critical as it did in this case, as the bonus entitlement would have been lost at the point of resignation anyway.
Yeah, I see, and that's a good point. And well, it's an interesting case, as you say, and it's definitely one to watch if there is an appeal to the Court of Appeal. So we will keep that one under review. So finally, thanks, Miriam, for that. I'm now going to mention briefly our third case, which is Coker against Angard Staffing Solutions. This is a Court of Appeal decision, and it's all about the 2010 agency worker regulations, which, as we all know, are designed to give agency workers the right to equivalent terms and benefits, by and large, when compared to an equivalent permanent employee employed in the client organisation where the agency worker is working. One of the specific provisions in the regulations is Regulation 13, which gives agency workers the right to be informed by the hirer, so that's the client organisation, of any relevant vacancies, so that the agency worker has the same opportunity as a comparable permanent employee to find a job within the client entity. And the question in the Coker case was whether this provision, whether this regulation means that an agency worker has only the right to know about relevant vacancies, or whether it goes further than that and it gives them the right to apply for the vacancy as well. And it's perhaps interesting, given how long the agency worker regulations have been enforced, that this appears to be the first time this point has come up. And not only did it come up, but it went all the way up to the Court of Appeal. And when it got there, the Court of Appeal said that the right is limited simply to a right to receive information about vacant roles, and it's not a right to be able to apply for them as well. And they looked at the European directive that the regulations are derived from, and they said that it was clear from that that a policy choice had been made to limit the right to one of information only. And they said that it would be very restrictive on end user clients if they could not give priority to their directly recruited employees when vacancies came up. And certainly I think if this case had gone the other way, it would have been a worrying decision for employers, because often when employers are looking to make redundancies, for example, the desire will be to give priority to permanent employees over agency staff, whether that's in selecting who's made redundant in the first place, or when it comes to offering alternative employment to employees who are selected for redundancy. And the Coker case confirms that as long as there is a mechanism for making agency staff aware of vacant roles on an ongoing basis, then that is as far as the employer will need to go. So that's the case of Coker and Angard Staffing Solutions. And that's the end of the podcast. My thanks to Miriam for joining. And as always, if you have questions about any of the cases we've discussed today or anything else, please feel free to contact either one of us. Otherwise, until next time, I hope everyone stays well, and I look forward to speaking to you next time. Bye for now.
Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.